Welcome everybody to our My HR Minute weekly webinar. It's great to have you all here. Today, as Dan said, we will be talking about hot topics going on in the workplace right now, things that have been popping up in the news that you may have questions about. So one of the things that has recently come down from the Supreme Court is the standard for religious accommodation in the workplace. What is an undue hardship when it comes to providing a religious accommodation to an employee? So most people know about ADA accommodations and the undue hardship exception to providing a reasonable accommodation to employees with disabilities. And many employers know that this is a very high bar to clear. There are a number of factors that are considered. You have to show action requiring significant difficulty, expense, meaning it cannot be mere inconvenience. So with the ADA, you can't deny an accommodation and say it's an undue hardship just because it's merely inconvenient to you. You also can't consider, when you're determining an undue hardship under the ADA, you can't consider employee morale or unfairness. Joe gets to be absent and we don't get to take time off, that type of thing. You can't consider the floodgates argument. If we accommodate this one person under the ADA, everybody's going to start asking for that accommodation. These are things that cannot be considered. So with an ADA accommodation, an undue hardship has to essentially alter your ability to do business, an inability to fill orders or serve customers or clients, harming the bottom line of your business. Something like hiring a temp to fill in for an employee on ADA leave so you can protect their job until they come back. Usually something like that is not an undue hardship, even though it is inconvenient and does involve an expense to the employer. Usually something like that is not an undue hardship. Time off from work, leave from work, usually not an undue hardship as well. So it's very high bar to clear under the ADA. Those are the kind of things that should be considered in those cases. Now, the ADA and religious accommodations had different standards as far as what undue hardship is. The previous standard for undue hardship for religious accommodation was it had to be more than a de minimis effect or on the employer, or a de minimis accommodation. So de minimis means lacking in significance or importance. So the previous standards was that employers did not have to provide anything beyond a de minimis or sort of insignificant accommodation to employees requesting a religious accommodation. The case that led to this standard was back in 1977, I believe, this was Trans-World Airlines versus Hardison. So in this case, the employee could not work on the Sabbath for religious reasons, and so the employee was transferred to a position with less seniority, which made it impossible to bid for a schedule with Saturdays off. And Trans-World Airlines believed that allowing him to have a 4-day work week would have impaired function of the airline, so he was terminated. And the court held that it was more than a de minimis accommodation to change the seniority system or arrange other schedules to let the employee have the Sabbath off. And therefore, Trans-World Airlines could terminate this employee because accommodating his request to have the Sabbath off was an undue hardship. So that's the standard that we have been working with for religious accommodations up until this year. Now, the new standard came down on June 23rd, 2023, where the Supreme Court revised the definition of undue hardship. Again, administrative burden of scheduling changes and impact on morale could not be considered. So now, instead of being a de minimis accommodation, the undue hardship definition is a substantial cost in relation to the conduct of the employer's business. So this new standard was Groff, the plaintiff in the case, was a postal worker who informed his employer that he could not work Sundays because of his religion, and the U.S. Postal Service, his employer, required Sunday work of all employees so that they could timely deliver Amazon packages. So Groff was disciplined for missing shifts because he could not work Sundays because of his religion. And he ultimately resigned. And this is interesting because some employers think if the employee quits, instead of getting fired, they don't have a case against the employer. That's not true. An employee can still sue you if the employee resigns from employment, which is what happened in this case. USPS was making Groff's job so difficult that he did resign, and that was the case that delivered the new standard, which is much more similar to the ADA standard as far as that high bar to clear. Is it affecting the bottom line of your business? Is it altering the way that you do business? Are you not able to serve customers and clients? So now the standard for religious accommodations is up there higher. I know that COVID brought a ton of religious accommodation requests relating to masking and vaccines. Now, under the new standards, businesses must determine whether allowing employees to go unmasked or unvaccinated causes substantial cost in relation to the conduct of its particular business. You should still use the interactive process when determining whether to provide a religious accommodation. You should not make employees or their spiritual leaders fill out a detailed form explaining their faith. But if you believe the employee's religious tenet claim is dishonest or insincere, you can request a religious text or a letter from a spiritual leader. So you can gather information just like you would do in the ADA, but you cannot force employees to write you an essay explaining their faith. Employee opinions on current world issues. This is a big hot topic right now. And so employees may have very strong feelings about things like the war in Ukraine, conflict in the Middle East, and other current political issues, laws being passed involving protected class status. So how these issues have been being addressed is that employees who have been expressing their opinions publicly in a hateful or aggressive manner have been terminated and have had job offers rescinded throughout the country. This is something that termination is happening when employees are saying things that are offensive or harassing to the public, to their clients, their customers, their coworkers. So right now, anti-Semitism and Islamophobia are really on the rise. And so what happened is we had cases like a physician who posted an anti-Israel post. He was promptly terminated because the post called into question his ability to treat Jewish patients and whether he could get along with his Jewish coworkers. And the employer said If you're going to post something anti-Semitic on X or Facebook or Instagram, we don't know if you'll be able to treat your Jewish patients fairly and with the best amount of care. So that physician was terminated. And other colleagues maybe feel threatened, harassed, discriminated against based on their religion or ethnicity. Make sure your handbook prohibits harassment on and off the job. Require posting, these are my opinions and don't reflect that of the company in your social media policy. You do not have to retain someone who has demonstrated strong bias or hate speech when it's clear that there is no way to separate the employee's public opinion from their ability to treat others, whether it's coworkers or customers, clients, patients. As far as anti-Semitism in the workplace, SHRM has a lot of helpful resources. They've recorded a podcast. They're hosting a webinar in January. They've written some articles. We can't link to SHRM through myHRcounsel because SHRM is subscription-based and does require a subscription to access their information. However, if you are a member of SHRM or you're interested in SHRM membership, you can certainly Google that, look that up, look up their resources on anti-Semitism in the workplace because they've got a lot of good stuff on that. The Illinois Day and Temporary Labor Services Act is a new law that needed guidance from the Illinois Department of Labor to let temporary and staffing service agencies understand how to follow the new law. So we had the law, we were just waiting for guidance. So the law was signed, the bill was signed into law on August 4th. It was amending an original act that had been passed, but this had changes including a wage matching requirement, safety assessments, notifying temporary employees of a strike or lockout. So these were new provisions that were added to the original act. So employers have been waiting for this guidance, and the Illinois Department of Labor has issued emergency guidance. They've just closed the comment period on what the final regulations will be, taking comments from the public. So they've just closed the comment period at the beginning of October and are debating whether to make their proposed rules into final rules. But for right now, the Illinois Department of Labor has a set of emergency rules, which is current guidance as to how to implement the law. If you have questions about how to follow the law, the Temporary and Day Labor Services Act, or how to interpret that, you can get those emergency rules from the Illinois Department of Labor. And again, that's specific to Illinois, but I do know many of our clients staff in Illinois, and we try to keep our clients updated with laws affecting their state. In particular, we've practiced in all 50 states. So we want to make sure that all of our clients have both federal and state law information. So if you're a California employer, you need to start looking out because California has passed a number of employment laws that and issued some case law that are going to affect all employers at the beginning of the year. This includes wage and hour laws. Not that California needed any more wage and hour laws, but they've got some, and laws affecting AI in the workplace will be really a really big change in California law. And they've also got some guidance for mental health in the workplace and going through the interactive process. So as far as the new batch of California laws and employment laws affecting your individual state that are going to be coming your way on January 1st of 2024, please stay tuned to myHRcounsel. We do give state updates. We do answer questions about new laws that you may have heard about that are coming to your state. We are providing state updates, and so just tune in, read our blog, follow us on social, listen to the webinars, and listen. We have a podcast that you can listen to as well on Spotify and Apple. So there's plenty of ways to stay tuned into myHRcounsel to hear about the new laws that will be affecting your particular state at the beginning of the year. Upcoming webinars, I think Dan touched on this. As far as some of our upcoming webinars, getting into 2024, let's hear from you. Send in your suggestions, or if you are a client, you can open a ticket. Otherwise, you can email info@myhrcounsel.com and let us know, are there things that you would like to hear webinars on, questions that you have that you would like more information in a webinar form. We take a lot of our suggestions from our clients and our listeners, so we would love to hear your contributions and suggestions. So again, open a ticket or email info@myhrcounsel.com with your suggestions from 2024. We'd be happy to hear them. So thank you all for participating in the webinar today. I appreciate everyone tuning in. Please register for our upcoming webinars and follow our blog and our newsletter. Thank you all for participating, and I hope you all have a great rest of your day.